court, or the court can potentially take judicial notice of that.
What is your exhibit 6? I think I
Well,
only got
exhibit
5.
6 is the one thing, and that's just a listing of my emails in December between myself.
That's
and
this one.
Yes.
An exhibit marker on it.
I'm sorry,
So
Judge.
that's fine.
And,
You guys feel like
exhibits 1.
and those are admitted for purposes of this record, which is the probationary.
Hey y'all, I'm trying to see what's going on with my boy Mounk. So I haven't been doing anything, so I said, let me go live. Let's see what's going on. And he has the same lawyer.
2 comes in at 5:06 p.m. And at some point I respond. Those are the only 2 exhibits or the 2 drafts which occur on the 27th.
Everybody.
However, it's important to note that when you see the response that I send
I hope
to
they
the email at 5:06, I send that response at 8:42. And I point out specific issues with the draft that need to be revised.
Right. Yeah,
Now,
and I recall we discussed this during the trial of this, the ongoing trial as well.
yes, Your Honor. And the point I won't belabor it is these revisions you actually see being put into the drafts. So by the time you see defendants 3 and defendants 4, they note that there's attachments updated to. You see that those very revisions that we requested are being put into the actual drafts. And ultimately, it was defendant's exhibit 4 that if you look on defendant 6, when the email comes in, it says, use this one. That is the agreement that we thought we were executing on the 28th. And remind you, on the 28th, we're in court. This isn't where I'm at my office. I can print it out, look at it, take it to the client like we did on the 27th.
Yes,
on the 28th,
On the 28th, both you and Mr. Sledge are in person in this courthouse,
correct. Right? So the emails, if you notice, I never respond because I'm here. I'm in person.
Right.
So we would get it and via phone, or if they would give me a draft, to take to him, I would literally go from the conference room back to the holding area. We would go through it, go over it. But the one that we thought was going to be the executed final was the same one that they said on defendants 4, use this one.
But are you testifying now, or are you just recalling for me the testimony from previously during this ongoing trial?
I am asking the court to take judicial notice.
I will take judicial notice of what both you and Mr. Sledge testified to in the trial. I recall it.
Understood. So ultimately, the last thing that I think we mentioned in our testimony was where we did take issue with some things. We said
to let y'all know that I'm on.
He'll have a chance to answer the question and to explain. Now, there was a big problem, and I noted in my testimony that number 8 on that version that got signed had been taken out, removed. All of a sudden it reappears and it's there. My client initialed it. Yes, it was tendered. But ultimately, here's the problem. My client has always said he does not know who's responsible for shooting the victim, who he never was a participant or heard about planning the murder of the victim. And therefore, number 8 was put into evidence by Ms. Love to the court when it was a knowing statement. She knew that statement was false. That is,
I'm not sure about that. That may be your contention, but
well, we would contend to the court that where
Yeah, he's scared.
my actual email
Yes,
defendants
I am,
two
Lamb. Actually,
clearly
off here.
denoted that.
Yeah.
It does not. That is up for debate what that denotes.
It is removed from all the drafts and then ends up back in.
That is true.
So,
But your response on your defendant's exhibit to item, what is then item number 4, does not definitively state anything like what you just said.
Okay.
He said he did not know, as we discussed
Man
at
got
the
a nice
time
great
of the
education
ongoing
from
trial,
y'all. Talk about your heart attack. You
could have been
good.
interpreted in several different ways. But I understand what you're saying.
and
Just
just
the right.
so
You maintain that the two of you both missed the fact that you signed, or your client
Hey, I'm gonna
signed,
get off here. I'm
a
gonna get off
factual acknowledgement that included item number 8.
correct.
And then when Ms. Love read it out orally in the court, and Mr. Sledge, one by one, said, yes, I acknowledge that
didn't listen.
somehow that didn't occur to you at that point in time either. So I understand what the assertion is. Here's the thing. You seem to be focused almost wholly, if not wholly, on, well, maybe there was a mistake with regard to factual assertion number 8. The issue that I see is that the state has not limited their petition to revoke probation to, he contradicted or he refused to acknowledge during the trial that item number 8. It is the entirety of disavowing factual acknowledgments, et cetera. And what got disavowed under oath in this trial was far more than just item number 8. It was item number 3, item number 4, item number 5, item number 6, item number 7, item number 8, item number 9, item number 16.
Oh, hell, she won't.
And then the part 5.
Paige said it wasn't just 8, it was half of the damn plea. It was more than half of the plea.
Sentencing acknowledgements, number 1, number 2, number 3, number 4, number 5, number 6, and the paragraph underneath asserting that he's read and that they're true and that he understands that he's had an opportunity to discuss it, and he voluntarily enters into it,
You get out, blame the lawyer.
So even if we entirely disregard item number 8 of the factual acknowledgements, there are still however many other ones that
these mushrooms make you feel.
Baby, he gonna have to throw him under the bus.
I don't see how you get around, and maybe you have a way to get around the rest of it, and I'm certainly willing to listen. But that one thing is sworn to in open court on December 28th of 2022, and then something diametrically opposite of that is sworn to under oath back on September 5th of this year.
I understand your concerns, Judge. One of the things that we traveled on after taking the plea was he would be able to explain his answers if he had issues.
Can I ask you a question about that? Is there anywhere in the guilty plea agreement in sentencing of
don't be nervous,
your client in December of 2022 where you reserve that, where anybody, the state, the defense, or the court puts on the record that that's part of the understanding?
It is not in the written plea agreement, no.
All right.
You're a lawyer.
However, in evaluating my client for the purpose of this hearing, I don't think the state is denying that that is something that it was understood. Understanding it's not in the written plea agreement, but it was understood. And the other thing to also take note of, my client, when asked to make himself available, to meet with the state, to be prepared by the state, at all times would show up and do that. He was never provided or questioned it with any details such as, here, let's go over your plea agreement, these factual allegations, what questions may be asked. In other words, what you saw at trial was someone who was now, after, what was that, December of 22, was now for the first time being drilled or asked questions rather, as to the specifics of all the things that he had allocated, all the questions that were going to be asked. There was no preparation of him. So what you saw was probably frustration on his part at times and shutting down at times on his part. But it was also part of the manifestation of what happens when a witness who's not a lawyer, who's not someone used to this, is getting questions fired at them. And at some point, I think the court can take note that he literally shut down. And some of what the court saw may be more of a manifestation of being overwhelmed as opposed to trying to purposely change or diametrically say something
I can
different
see this argument.
than what ultimately he allocated initially. So I, in retrospect, wish the state had actually, more than general questions, actually prepped him like you would normally see a witness be prepared and
Trying to
prepped.
put it back on the stage.
That did not happen. So you saw a very raw witness recounting things that
think this is a
happened
good argument.
quite some time ago, and did not necessarily say things consistent with what he said before. But it wasn't simply for a malicious intent or an intent to deceive. There were several factors, is all I'm indicating, that may well explain why it was so difficult during his testimony.
Take one for me too, Audrey.
All right. Anything else you want to present?
Oh, it's
Your Honor, not at this time, no.
All right. Can the state give me a quick rundown of what this defendant's prior history is, including any prior probation violations? And then I guess I know that the probation officer is on here, so I'd probably need to at some point ask that officer if they would like to be heard as well.
And Your Honor, we would defer to probation as it relates to, I know they have a full account of his history as
All
it
right.
relates to.
You know what? I think I'm still on Zoom.
Yes, Judge.
Yeah. And what's the officer's name?
That's Jolly.
Oh, it's my regular probation officer from long ago, whom I haven't seen in the last
right.
2.5
Don't throw
months
yourself
because I've been
Paige's
otherwise
feet.
occupied.
Beg like Booty said love be doing.
Hello, Judge Whitaker.
Hello, I'm trying to, oops. Okay, I'm trying to get myself on video. I know. So that it's not a disembodied voice.
Mm-hmm.
Hang on.
I get the argument he had, but I'm just saying. He trying.
All right.
He gonna have to throw
Hello,
himself
Officer
out.
Jolly.
Hello, Judge.
All right, what is probation's, can you give me a rundown of Mr. Sledge's criminal history? And I'm sure you heard the question I just asked, as well as any prior probation violations.
Well, currently, he'd used his first offender twice, one for DeKalb County, one for Fulton County.
Well, that's lucky.
The DeKalb.
Since you're only supposed to get to use it once, okay.
Yes, so the DeKalb County case 04CR 24799, that was theft by receiving stolen property, felon, and a obstruction of law enforcement officer, which was a misdemeanor. That was May 19th, 2005. I'm sorry. He used his first offender. The second case 04SC 23883. That's Fulton County. He used his first offender. That was possession of cocaine, as well as a possession with the intent to distribute cocaine. That was December 10th, 2004. The possession with intent to distribute cocaine in Fulton County was January 3rd, 2014. Again, both times, all three times, he used his first offender. The next case is 15 SC 138994. That is a Fulton County case. That is the gang participation, aggravated sex battery, attempted aggravated sex battery, aggravated battery, aggravated assault,
Jesus.
criminal damage first degree, criminal damage second degree, and possession with the firearm by a convicted felon.
He's
That was
still
January
going.
10th, 2018.
All right, so given the fact that he had at that point a possession of a firearm by a convicted felon, does that indicate that at least one of those first offenders was not successfully completed?
One
Or are we
moment.
missing a felony?
One moment.
Like, it ain't looking good.
He was adjudicated guilty.
Jaleesa talking about candle on.
That would be correct, Your Honor. In addition, of course, the current case that he is currently on probation on. As far as previous revocations,
So, hang on.
Ain't
So
nobody
the
asked you
15
that, girl.
SC, and then this 22 SC case, right? Is there anything
Correct.
between the two of them?
there's nothing in between the two of them, no.
Okay. Are you looking about prior revocations or prior violations?
Yes, at this present time, I don't see any prior revocations.
Good.
There was one documentation. It's a little bit, I guess, I'm having a hard time understanding what they meant by it.
She want to go star. My girl want to go star.
One moment.
Judge, while she's pulling that up, there is a 13 SC 123
Look at Mr. Bot.
423 out of Fulton County. It's a BGCSA, possession of cocaine with the intent to distribute, where the defendant received 5 years probation on January 7th, 2014, which would be the predicate or basis for the possession of a firearm by a convicted felon of the
I
15
figured
SC.
there had to be something else there. Okay.
Sorry, I should have spoken sooner.
Baby,
I
he
apologize.
going back. He
Appreciate
just
it.
gonna have to get him a lawyer that say that his little friend did him wrong. He might be about to go. It's not looking too good, but Paige might shock us.
Yeah, the only documentation that I have regarding a revocation just said revoke closed July 16, 2008.
Oh,
Doesn't
okay.
really show any actual time served or any time being revoked or continued on probation back in 2008.
Okay.
So I'm unsure if that's an actual revocation that was completed.
Okay,
he
well,
serves his
yeah, it
probation.
sounds like maybe it was revoked, but it was just wrapped up in something else is how I would take that. I don't know, but, or that that a violation was found, but we don't know what that was or anything like that. All right. So does probation have a recommendation in this case?
Due to the last minute notification of this probation revocation, I would leave that up to the courts to make that decision.
Okay.
Mm.
All right. Well, I find there to have been a violation as alleged. And again, even discounting the item number 8. What is the state's recommendation?
Send him to jail.
In full candor to the court, Your Honor, I'm going to leave it. The state is going to leave it in the full discretion of the court. Your Honor is fully aware of the conditions. Your Honor witnessed the testimony and how it affected the trial of the case. And I'm going to let Your Honor be the full steward of deciding what the penalty should be as it relates to all of the time that Mr. Sledge still has remaining on probation.
All right, well, I know that at least, I believe in the petition for revocation, the request is that the entire 30 years be revoked, is that right?
It's not the
Or
request.
is,
Good code is good. We don't touch that. But for everything else, there's Sentry.
Sorry,
did
y'all.
he serve it? What's left?
He
did-
just started on December 8th of 2023. I think he got credit for the
And we
time.
got 28
I
years,
think he was in
29
for
years.
2 years. So he would have 26 and change or 25 and change.
I'm sorry, correct, 22.
My bad.
Give the exact number. Come on.
I know my boy got it. I'm just gonna say, I hope a new lawyer come and take all this away.
That would be 27 years, 7 months, and 8 days.
all right.
Where the hell we get 22 from?
All right, thank you. Anything else from either side?
No, Your Honor, nothing further from the state.
Your Honor, if it'll please the court, I understand the court's ruling that there's a violation. Ultimately, I guess to some degree, while it's not clearly akin to a substantive versus technical violation of probation, it is a non-violent, non-new offense kind of violation. And I would say if the court is going to violate my client, it would be more germane to treat it as a technical violation. We have expressed to the court different thoughts and reasons for the way the testimony came out. We don't know what effect, if any, one way good or one way bad, that has had. But in terms of his violation, I would ask the court treat it more as a technical. He has one grandchild on the way, one that just came early this year.
Come on.
With Ms. Jaquila Freeman. So the point is, he has been staying out of the way. He's been complying
He
with
said,
probation.
stand out of the way.
I would ask the court to maybe consider if you want to put more restrictions and make his probation much more of a, not just something he's on, but something that now has more teeth to it because he's been working. He's been taking care of his family.
He be on live
staying out of
every day
trouble.
making money.
He's turned that corner.
He
And
has.
literally, it was always our hope he wouldn't have to come in and testify. And there was a reason the state allowed this plea to go forward so that he could step away. And in doing so, if you recall, you may have remember from his testimony, by no fault of his, he was a victim of a crime where he was shot multiple times and had to recover from that. So we would ask the court to consider some restrictions first, as opposed to custody. And if you do go with custody, we would ask to consider it as a technical type of violation, not a substantive violation in which you would be authorized to give him an even greater sentence. So we would leave it in the discretion of the court, but we're asking again for a non-custodial revocation punishment.
Okay, well, I don't view it as a technical violation or akin to a technical violation, considering
I knew she was gonna do this, baby.
the solemn oath that he took when he said that he understood every term within the
I knew
plea agreement, factual acknowledgements, and sentencing acknowledgements, and understood and, in fact, orally answered that he understood when both asked by the prosecutor and the court at his plea hearing that a failure to abide by any of the terms would constitute a violation of the agreement, and he was notified that the entirety of his probation could be revoked. I do appreciate the fact that this particular violation is a non-violent violation. But I also appreciate the fact that some of the many why this could have occurred include the fact that there is just not a proper regard for the judicial system and the seriousness with which an oath in court needs to be taken.
Wow.
I actually view this much more akin to perjury, frankly, than a technical violation. And the sentence for perjury is up to 10 years. I am going to revoke 5 years of Mr. Sledge's probation. And Mr. Sledge, I am sympathetic to the fact that you have generally stayed out of trouble, and I want to commend you for that. And I really hope that this revocation doesn't set you back. But we've got to take seriously the court system. So that's the sentence of the court. I find there to have been that violation. I'm revoking 5 years.
Does that mean he's got it on
He will be continued on probation, Your Honor?
Yeah, and reinstate the balance.
Thank you.
Might I ask, is it possible for my client to turn himself in to make arrangements?
I think y'all knew when you came in here that this was a strong possibility. So, no, I'm sorry. All right, court is adjourned.
Bro.
Good seeing you, Judge Whitaker.
Yes, thank you. Good to
Get
see you.
off that Zoom.
All right, bye.
The only person we could hear was Miss Jolly, so the only person we could hear was Miss Jolly,
Oh, wow.
not on Zoom.
I don't know, the sound in
Jolly
this
had
courtroom
bad
is.
guts. Go to the next room. Okay, so
I looked at you, I said, I thought she said she won't come down here.
And when I tell you, Adrian Love,
all right.
maybe that office.
Oh, we need the order from Miss Jolly. Did you find
Yeah, I just don't have no words. I'm fighting my tears.
myself?
I think what bothers me the most is it really feel like people were trying to like y'all. What bothers me the most about this is this so personal. This shit is so personal. Look, Adrian, and she got that ugly ass orange purse again. It's so personal. That's what bothers me the most about all of this, y'all. It's so personal. It's so personal. I just don't have no words. I wish you would have got another lawyer. Brittany, it's not our job to raise money to get him a new lawyer. I didn't somebody said something about a GoFundMe. I just had a lot of stuff going on. I didn't check it again, but I'm sorry. I'm thinking Mounk is gonna be able to get another lawyer who's gonna come in and throw Derek right under the bus, and when he get through, he won't have a law license fucking with me. Oh, I don't know if I could say that word. He wouldn't have a law license, and the problem came from the agreement that his lawyer made. It all stemmed from the lawyer. It all stemmed from the lawyer. The lawyer couldn't speak up, Shantae, because she don't know anything. Today, India. Even if the lawyer didn't, another lawyer could come in just like on appeal. You get a new lawyer on appeal who represents negligence that your original lawyer did. It's the same thing here. Baby, y'all saying the PO, what was the PO lady gonna say? She said it was too soon. She couldn't research. Accountability for, hold on, I missed the things. Mail, have you pulled your films out now for the second minute? Girl. Yes, Miss Cherie, 5 years. I think it's just so sad because the state just been allowed to do whatever they want with these young men, whatever they want, good, bad, ugly. They get to do whatever they want, and the judges on the bench just roll with it. I think that's the hard part about this. Baby, this case, when I get off here, I just don't even want to hear nothing else about this. Erica, maybe it takes more than 5 days. That's what she was making it seem like. I don't know what the probation officer could have said, y'all, that would have helped him. I think Paige's mind was made up. She's a former prosecutor herself. Her mind was made up before he walked in their courtroom. Something was going to happen. Did you hear her say, no, this is not technical, this is perjury? She's basically saying he lied on the stand. When, in my opinion, his attorney sitting here trying to argue that, oh, he could have changed. He was told by the state he can change what he said. You're a lawyer. Get it in writing. Or not even that. Why would you have him sign something and then be okay with him saying something different on the stand? It just make sense. It doesn't make sense to me. I think Mounk is going to get him another attorney. I'm not surprised either, Isis. Yeah, Key, I'd rather 5 than 32. Dang, though. Paige, it's not Paige. This whole case is just, it's almost like, can somebody no one can step in and save these young men. And y'all, I go back to the fact, I'm not saying they innocent of everything that they, because we just heard Mounk's list, but he clearly was trying to change his life. This is clearly get back from the state. Man, they agreed under oath. They sure did. India, we get why she said it's perjury. That's not the argument. We get why she's saying it's perjury. I'm just saying that his attorney, for him to be okay with the boy openly committing perjury, because he's like, oh, well, we signed it, but they said we could change it on the stand. You know that's perjury. And you had him sign that. Why him and Big? I don't know about Tick and DK. Hell, they may go do them too. Man. I feel bad for him too, because he really was trying to cheat. I mean, these people, this shit happened. Oh, I'm sorry for cursing. This happened almost 10 years ago. You know, if it was this serious, these people should have been locked up then. And not only that, his attorney has maintained they were supposed to be lay witnesses, didn't even think they were going to call Mounk for real. Everything went left for Woody, and boom, here go Mounk. It's very disturbing. But I will say this, people, I think you're getting a front row seat. You're getting a front row seat to the justice system, what the justice system looks like for people of color. You're getting a front row seat to why it's important for you to go and vote locally in your city, because people in Fulton County put Paige on their bench. Y'all put Funny in office. People also, Mariah, can you close that door? Because Bart's still out. You put Funny in office. Like, y'all have to understand that when you vote on the local level, it's one of the It's one of the offices you can actually go out and touch these people. You have a say. So I think as the country as a whole, we are seeing how important it is for us to get out and vote. Y'all know I'm not gonna take nothing political, so don't y'all start in these comments. Don't start in these comments. But I am saying that you need to be aware your voices matter. Everything throughout your city goes back to you. Everything goes back to you. You know, just that's all I'm saying. Read and understand what you're reading. I mean, here's the thing, y'all. Mounk has a 9th grade education. You can't expect him to really, for him to understand everything that has transpired in this case. Hell, I've got some college education, graduating December, and I have to go back and truly look at what I'm reading, using dictionaries, using a lot of stuff. So it's not about just reading and understanding. Everybody does not have the capacity to do that. You know, everybody doesn't have to have the capacity to do that. And so, like, you just, man, everybody doesn't. Yeah, I'm sorry, but y'all see Barty's just loud. Everybody don't have that capacity. Hold on. She gonna have to sit down. So they say even Barty, yeah. I just think at this point, I thought he was gonna have a new lawyer. I did. Man, I thought he was gonna have a new lawyer. I just did. I felt like his testimony on the stand was enough for me to say, I'm gonna have you look, we friends, we cool, but I'm gonna get somebody else to represent me. I think he needed another lawyer. Now, Love was mad he didn't get that 27. Agreed. They said even the dog pissed. Don't mind Barty. You got to be new here because Barty is always like this. Quindarius didn't have he does have probation, but I don't think his probation is tied to this case. Moonk's probation was tied to this case. I was definitely shocked to see that same. Me too, Toy. I thought he was going to get another lawyer. He did. He has to serve 5 years. He has to serve 5 years. I wonder too, guys, why didn't they work out immunity for Mounk? I wonder why. Ineffective counsel. Those are the 2 words Mounk need to be studying why he's there. At this point, nobody needs to sign that deal and take the 5th. India, you saying 5 years in prison, not Wright Street. That's still jail. I don't know, y'all. I don't know, y'all. Can it be appealed? It's not Fulton County. I think I appreciate that this case has gotten so many of us to watch it. But what I can appreciate more is the things that we learned from this case. And I hope that you guys aren't just watching solely for entertainment. I hope you're learning, right? There are so many things that have so many things, and I say this all the time, there's so many things in this case, and I hope that you guys are watching and learning because you have children that look like those young men in that on that case. You've got cousins, brothers, sons, nephews, that grandchildren that look like those young men, right? Everybody doesn't go down the right path. Sometimes people go left. And so this case is, in my opinion, preparing you. You can understand what the rules of evidence are, what they can't use. You understand the probation and what it looks like to have your probation revoked, who's involved in that. You're understanding plea deals, the importance of reading plea deals, the importance of advocating for immunity deals before you will take the stand. You're understanding what forced immunity looks like. Y'all, I didn't know that was a thing. I thought you had to ask for it. I didn't know that was a thing. But y'all not gonna sit on here and say y'all didn't see this coming. Miss Love set this up when she was questioning Moonsoon. Miss Love literally said, "Oh, let me get you a pen. Let me get you some paper." We knew then she was gonna revoke it. I have a video saying it. People on Twitter, everyone was saying it. Y'all knew it. You knew it. What did she tell them, y'all? She kept saying, hold on. She kept saying, oh, and what other one? And you could tell by the way she was acting. And what else? She was like, and what else? Number 8. Okay, which word? All of it or just the first sentence? Oh, the whole sentence? Okay, let me put, like, y'all knew it was coming. We knew it was coming. We knew it was coming. Y'all, she'd gone through Tick, who ran circles around her. DK did something similar. Woody really embarrassed them. Woody got their judge thrown off the case. By the time she got to Moontoon, she said, I'm done. I am done. She said, I am done. You knew it. You saw him. Yes, India. That lawyer failed him terribly. But you knew it would. Barchi, stop. You knew it. Like everything about Miss Love going over that plea deal. She's like, oh, the first part of the whole part. Like, it was just how she was doing it, y'all. What else? Oh, do you need me to read it to you? I knew it. I knew she was doing that. I knew what she was doing when she was up there. This was very personal. And Miss Love, funny, y'all can't think this is going to help your public perception. I wouldn't be surprised if Funny just sealed her fate. I don't know. Now, they say she's up in the polls. I hadn't watched. I don't live in Fulton County. But I wouldn't be surprised what would happen with Funny after this. I don't know. Maybe nothing will happen. But because we do have to think about this too. Most people that are disconcerted, they're not in Fulton County. That plays a big part in this too. It's gotten too personal. It's personal for that office, baby. It is personal for that office. But I'm with y'all. Karma is real. Her time is coming. Yeah, I've heard this too. I've heard that too. But the last time someone showed me, she was up in the polls. She had raised way more money. So honestly, I understand it. I understand why Funny's up in the polls. But again, I wouldn't be surprised if, I don't know. I don't know if people are watching the case like we watch it. Some of us, we watching and we trying to see everything. We have a soft spot for certain people in the trial, and we're looking at it from different lenses. But we also don't live in Fulton County. We're not affected by the alleged violence that Funny is saying is running rampant through Fulton County. So that plays a part in it too. I think so. Ms. Stater, I believe so. Jasmine, if I were Moontoon, y'all remember we talked about this when it first came out on my live. I would have thrown that lawyer under every bus I could. And if I got a new lawyer, I'd make sure that lawyer know that I don't have the mental capacity to have gone behind my lawyer. I was barely even listening. I can't even tell you what was said during that hearing. I just raised my hand. Then Moontoon did point out he raised his left hand, not his right. I don't know if that would mean something in court. I don't know, but I'd be trying to look at everything. I'd be looking at everything. And again, I'm going to say it again to people. I said this about my personal situation. When you're hiring a lawyer, make sure you pay them. Make sure you pay them. He did, India. We saw the hearing. I'm not disputing it. I was specifically talking about the oath portion. I was specifically speaking about the oath portion, India. I don't know if it even if he was agreeing to it. I'm not sure. I wondered if it would cancel out the oath. I don't know. So that's what I was wondering, if it would cancel out everything. I'll be in there in a sec, okay? Oh, you look handsome. That's my baby, y'all. My son just got here. But yes, y'all need to pay your people. Pay your people. And I think that man, Mounk said he didn't have the money to take it to trial. I understand that. This trial has been going on 144 days, and that's not including jury selection and all of that. So I get that. And so his lawyer said, hey, the best thing for you to do is for us to take a plea. But he didn't even read it. Like, that's what you pay him for. You pay him for that. And I'm telling you, personal experience, pay people, okay? Sometimes your friends are not always going to go to bat for you. Jan, I know you don't be on Mounk lives doing smash or pass, talking about he not gonna be live today. You heard he really was trying to do something positive with himself. Like, this case has given him the opportunity to do some other stuff. Yep, say that. India, you ain't wrong when you right. You ain't wrong when you right, India. Mounk could have been sitting there by himself, because how you let them slip number 8 in? Y'all think Brian still would ever let that happen? Stop playing. He would never let that happen. Never, ever let that happen. It's too much, y'all. It's too much. Brian still would never have let that happen. And they told me before this happened that Mr. Wright had some bad reviews. I can't imagine what's going to happen with those reviews. I hadn't even seen them since then. I can't even imagine what his reviews are going to be now, because you have just, to me, publicly ruined your reputation. Not only that, you got on that stand and said a whole bunch of nothing. And now your client has had his probation revoked because you didn't advocate for him before. His plea deal revoked because you didn't advocate for him. Now he's got to go serve 5 years. Yeah, them reviews ain't gonna be fun. Whoop! Now, India, you ain't got to do all that now, friend. His lawyer, and this is something you have to think about when you are in a position where people's lives are in your hand. You got to check, double check. Nothing can get past you, because if it gets past you, when it comes back, it's gonna come back to bite your client in the butt. Like, I didn't understand why the lawyers would always stand up and say, can I have a continuing objection? Or even sometimes we think the objections are silly. Even from Ms. Love, they say these objections have to be made on the record, because when you go back and look at the record, we need to see that you objected to it at that point, right? I didn't understand that. But now it makes me further understand that, everything lawyers do, they always have to be doing with the intent, with their clients on their mind. Always. Well, I'm about to get off here, y'all, because this isn't much, and my baby just got here. My son just got here. It's his birthday on Sunday. So we've got to figure out what my baby wants to do for his birthday. He's turning 13. So I'm gonna take this weekend, spend some time with my son, my daughter, because she's here from school too. And man, I don't have any words. The most I can say is y'all really say a prayer for his children, because he seems like a very present father. If I get any information, his daughters, if they message me or anything like that, y'all, I'll make sure that I update you guys, because I did see in the comments, kind of want to keep up with what's going on. So I will for certain reach out to you all and let you know whatever information I have. She said, does Mounk have family? He has 8 kids. 8. Excuse me. He has 8 kids. But I will, Zaria, I am too young to have these kids, girl, okay? My daughter will be 19 in November. She's in college. So I'm, in fact, too young to have these kids. Your eyes are not deceiving you, child. I had my little girl when I was 18. If y'all don't hear this 18, don't be like me, okay? But no, it's kind of fun because she's 19. She'll be 19. I'm 37, and we're like besties. but yes, y'all, I will make sure that I let you guys know whatever information I receive. But thank y'all for watching. Send a prayer up for them. And man, this trial's never a dull day. It's probably gonna be another surprise soon, but I'll see y'all later. Thank you for joining. Bye, y'all.